He then appeals, saying that this law violates the notion of equal protection of the law. The Supreme Court of Oregon looks at his appeal and affirms the trial court. They said that Mrs. Gotcher worked more than 10 hours, that violates the state law, and that the state statute is constitutionally valid. So then it goes to the United States Supreme Court. And as part of this case, we have one of the most famous amicus curiae of all time. An amicus curiae, which is a friend of the court brief. In other words, you're not a direct party to the case, but you want to provide your arguments on behalf of one side or the other. So an amicus curiae brief was filed by Louis Brandeis, one of the most notable legal minds in the history of our court system. And he did this brief in support of the state of Oregon, supporting state limitations on women. And what he does is he states his famous, some say infamous, what he calls facts of common knowledge. Facts of common knowledge that explain why it's perfectly okay to treat men different than women. And what he talks about are, he said, first of all, we all know about the comparative physical weakness of women. Secondly, that there's also a greater disposition to the harmful effects and elements of the trades on women. Thirdly, that we all are aware of the significant effect of work and labor on the reproductive organs of women. Fourthly, we all know that allowing women to work would have a significant effect on their children and offspring. Then he says, and we all are aware of the problems of menstruation. Holy cow. So he's saying, how could anybody in their right mind think that men and women can be held to the same standard when we know these are irrefutable differences? So that's the mindset, the legal mindset, the cultural mindset, the social mindset of society in the early 1900s. Now, the majority opinion in this case was written by Justice Brewer. And Justice Brewer states that the February 1903 Oregon legislature passed laws that said that no female shall be employed in any mechanical laundry for more than 10 hours per day. The defendant Muller required his female worker, Mrs. Gotcher, to work more than 10 hours per day. So in accord with the Brandeis amicus curiae, the justice writes that a woman's physical structure and the performance of functions required place her at a disadvantage in the struggle for subsistence, and that this is obvious. He says this is especially true when the burden of motherhood is imposed upon her. The physical well-being of women becomes an object of public interest and care in order to preserve the strength and vigor of the race. So we got to protect women from themselves. Otherwise, they'll screw up society. And he says, still again, history discloses the fact that the woman has always been dependent upon man. He established his control at the outset by his superior physical strength, and this control in various forms, with diminishing intensity, has continued to the present. Legislation designed for her protection may be sustained even when like legislation is not necessary for men. The state justifies legislation to protect her from the greed as well as the passion of man. What? So what the court's basically saying is we have to pass these laws to keep men from exploiting women. Because God knows that's what men would do given their own devices. So we have to pass these laws in the best interest of women, whether they know it or not. These differences, the justice argues, justifies a difference in legislation. So therefore we affirm the holding of the Supreme Court of Oregon. Okay. Well, in the wake of Mueller, many states enact legislation that limited women's employment in many, many different ways. So 19 states limited the length of the workday for women. A number of states said that women could not work at night. And then, as we've already pointed to, many states had prohibitions against women working in various professions. And this would vary from state to state. Okay. Well, let's talk about Gossert versus Cleary. A 1948 decision, which also deals with employment. 6-3 decision by the United States Supreme Court. Frankfurter writes the opinion. And this case deals with a Michigan law that says no female may be licensed as a bartender unless they are the wife or daughter of a male owner. So women can't be bartenders. Well, unless they're the wife or daughter of a male owner. By the way, my daughter, when she was an undergraduate, was a bartender. Nicole, the one who went to Harvard. So the claim is Michigan is not allowing women from being bartenders, but at the same time it's making an exception for wives and daughters. So the claim by the women's rights groups was this violates the equal protection of the 14th Amendment. How can you exclude women from the bartending profession, but then make exceptions for some women? That became the question. And here's how the Supreme Court answers that question. They say the 14th Amendment did not tear history up by the roots. And its regulation of the liquor traffic is one of the oldest legislative powers of the states. That Michigan could beyond question forbid all women from working behind the bar. He said, there's no doubt about that. I mean, if we want to just forbid all women, they can do that, and there would be no controversy. So the issue is it's still okay to discriminate if you're allowing some women to have a right to do it. And to that, the answer is, he says, the Constitution does not require sociological insight or shifting social standards. The legislature need not go to the full length of prohibition if it believes that as to a defined group of females, other factors are operating which either eliminate or reduce the moral and social problems otherwise calling for the prohibition. What? So one of the things that they're saying is that women could be denied this right to become bartenders because of moral and social issues and problems. Clearly, you got a moral problem if you have a woman bartender. You're going to have a social problem. God knows what it'll lead to. Wanton sexual conduct, I don't know. So, based upon that argument, he argues, it is not unconstitutional for Michigan to withdraw from women the occupation of bartending, even if it wants to do it on a limited basis. And I'm going to read the actual language from the case that kind of paraphrases this. So, Frankfurter writes, quote, "We are, to be sure, dealing with an historic calling. We meet the alewife, sprightly and ribald in Shakespeare, but centuries before him she played a role in the social life of England. The 14th Amendment did not tear history up by the roots, and the regulation of the liquor traffic is one of the oldest and most untrammeled of legislative powers. Michigan can beyond question forbid all women from working behind the bar. This is so despite the vast changes in the social and legal position of women." Now, I'm not too sure what these great changes are at this point, especially given this decision. The fact that women may now have achieved the virtues that men have long claimed as their prerogative, and listen to what it is, and can now indulge in vices that men have been long practicing, does not preclude the states from drawing a sharp line between the sexes, certainly in such matters as the regulation of the liquor traffic. So in other words, what they're saying is, hey, we let women drink now. Wow, we've come a long way. But just because we let them drink doesn't mean they have rights of employment. The Constitution, he continues, does not require sociological insight or shifting social standards any more than it requires them to keep abreast of the latest scientific standards. Gee, maybe it should. Maybe it should. Isn't that what Roe v. Wade incorporates? Doesn't scientific standards have a major impact on how they write that opinion? All right. And then to bring it up even further in terms of contemporary cases, these kinds of distinctions that are being made, let's look at Hoyt versus Florida in 1961. A 9-0 decision by the United States Supreme Court. Interesting case. Gwendolyn Hoyt had killed her husband with a baseball bat and was convicted of second-degree murder by a 6-person all-male jury. A jury that deliberated for just 25 minutes which is almost unheard of. And they sentenced her to 30 years in prison. So Hoyt appeals the decision, claiming that the Florida law that did not require women to serve on juries unless they volunteered was discriminatory and a violation of her rights, 14th Amendment and others. And how can you have due process of law when you don't really have a jury of your peers? And by the way, at the time, 17 other states had similar laws. So according to these laws, men were required to serve as potential jurors, but women weren't. They had to volunteer. Now, how did that work? Well, to volunteer, a woman had to register with the clerk of courts for Hillsborough County. And out of the 46,000 women in the county, only 220 of them registered. Now, Gwendolyn had pleaded temporary insanity, claiming physical abuse, mental abuse, and the fact that her husband was cheating on her, which has exacerbated the situation and her condition. The law in the Florida statute, quote, requires that grand and pettit jurors be taken from male and female citizens of the state, provided that no female person shall be taken for jury unless said person has registered with the clerk of the circuit court her desire to be placed on the jury list. So it goes to the United States Supreme Court. The Florida courts uphold the legality of this approach and its constitutionality. And Judge Harlan writes for the majority. And he says, the question is, can we conclude that Florida's statute is not based on some reasonable classification and that it is thus infected with unconstitutionality? That's kind of awkward language, but that's the way he posed the question. And he says, despite the enlightened emancipation of women from the restrictions and protections of bygone years, the woman is still regarded as the center of the home and family life. Now remember, this is 1961. He says, we cannot say that it is unconstitutionally impermissible for a state acting in pursuit of the general welfare to conclude that a woman be relieved from her civic duties of jury service unless she herself determines that such service is consistent with her own special responsibilities. Her own special responsibilities? What the heck does that mean? He says the 14th Amendment reaches arbitrary exclusions. So in other words, you can only apply the 14th Amendment if it seems arbitrary. And he said, this is clearly not arbitrary. 17 states and Florida provide for these exemptions, so it can't be arbitrary. He said it's not offensive to the 14th Amendment. Why not? Well, listen to the explanation. It says the failure to add more women is not attributed to any discriminatory motive. Instead, it protects women from the filth, obscenity, and obnoxious atmosphere of the courtroom. Holy cow. So we got to protect women from the courtroom because it's filthy, obnoxious. and obscene. But obviously men can deal with it. So again, this kind of relates to the Fifth Amendment too, though, which tells us you can't deprive people of life, liberty, or property without due process of the law. Is this due process? Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state. Is this an impartial jury? Well, this issue is addressed later on in terms of court trials in Jebb versus Alabama. And this will be the last case that I talk about in 1994. And it goes to the United States Supreme Court. And the decision of the Supreme Court is 5-4. So it's a very close decision. And Justice Blackmun writes the opinion for the majority. And the question is, does the Equal Protection Clause of the 14th Amendment forbid intentional discrimination on the basis of gender when exercising preemptory challenges? And just to kind of inform or remind people, if you've heard it before, about what is a preemptory challenge, that's when you're impaneling a jury and you get to just exclude someone from jury participation unilaterally. So if I don't like somebody's looks or somebody's background or whatever, I can say, Your Honor, I want to exclude them, and they will automatically be excluded. A preemptory challenge. Now, when you look at this case, the state of Alabama had filed a complaint for paternity and children's support against JEB. There were 36 potential jurors, 12 males and 24 females. The state used 9 of its 10 preemptory challenges to remove all the males. And Jebb used all but one of his challenges to remove all the females. And what ends up happening is all the jurors were females. And they're pretty much honest about their motivation here. He didn't think women would give him a fair shot, and she didn't think men would give her a fair shot. Or the state of Alabama didn't think they would get a fair shot from men. So the court, in looking at this, and Blackmun, again writing for the majority, says, our nation has a long and unfortunate history of sex discrimination, which warrants heightened scrutiny. So what we see is all of a sudden the embracing of this standard, a new standard, heightened scrutiny. That if you were going to make differences based upon gender, that by definition those differences are subject to heightened scrutiny by the courts. It says the only question is whether the discrimination furthers a state's legitimate interest in a fair trial. And to this, the judge argues there is no support for the conclusion that gender alone is an accurate predictor of jurors' attitudes. The Equal Protection Clause prohibits discrimination in jury selection on the basis of gender or on the assumption that an individual will be biased in a particular case for no reason other than the fact that that person happens to be a woman or a man. So this case of Jebb versus Alabama in 1994 is a critical turning point, as are a few other cases during this era, in applying a different standard in regard to gender discrimination. And there are a number of justices who determined that equal protection analysis did apply to gender-based laws. And they come up with this standard. So the standard actually, has two prongs. First, what is state action? That's something we've talked about before. So private parties can't violate the Equal Protection Clause. We talked about in the context of race. And broadly defined, when we talk about public entities, we're talking about states, county, local governments, as well as government-operated facilities, schools, universities. And it also hinges on this notion of the meaning of equality. So it doesn't require that people who are different be treated the same, but it's saying you have to prove there's a real difference. So in this case, we have more of a strict scrutiny approach. And for strict scrutiny, the burden is on the public entity to prove that it's not discriminatory, not on the challenger. And the objective is, if there is a distinction, it must be compelling and necessary. A new approach. And we'll end here. And our next lecture will start off with Reed versus Reed. Then talk about Fontiaro, Craig versus Bourne, Orr versus Orr, Michael M. And let's see if we get through that. So have a great day, and we'll talk to you again soon.